Minister Yaacob.
Mr. Speaker, sir, first let me thank all the honourable members who have spoken. I will try and respond with creativity within the container. The majority of them, sir, have expressed support for the amendments and raised interesting views and questions. I will address their views in 5 broad areas. First, members spoke about the co-classification scheme, so I thank Mr. Zaki Muhammad, Mr. Darul David, and Mr. Ganesh Rajaram for their support for the scheme. In fact, IMD has been engaging the industry closely, and distributors and exhibitors have expressed support for the scheme. This is because the classification process is faster and cheaper for participating companies, which will only pay a flat fee per film or video title rather than a fee based on the title's duration. Mr. Zaki Muhammad also asked why IMD was outsourcing its classification duties. So I wish to clarify that we are not outsourcing, IMD is not outsourcing its classification duties. Instead, as I've just explained, the co-classification scheme aims to help our film industry to distribute film and video titles more quickly and to save costs. This is one of the ways in which we develop and grow our film industry. Mr. Zaki Muhammad and Mr. Darul David also asked about the potential challenges in implementing the co-classification scheme and the safeguards in place to address misclassification risks. IMD, sir, has considered this carefully. First, the prospective film content assessor or CAs will be required to attend formal training and pass the mandatory test before qualifying for registration. Film CAs must also fulfill an annual retraining requirement, and when in doubt, they can consult IMDA on a film's appropriate rating. No other strict academic requirements are necessary. Second, film CAs can only co-classify films up to PG-13 rating. IMDA will continue to classify films that exceed the PG-13 rating. IMDA will also classify certain categories of films regardless of rating, such as films intended for film festivals and those that deal with matters of race or religion. Third, IMDA will conduct regular checks on co-classified film titles and reclassify those that are misclassified. The relevant company will have to replace the classification labels with the right rating and bear the associated costs. So after the FA is amended, regulatory action can also be taken against the errant film CA. IMDA will carefully consider the facts and circumstances of any case before determining the appropriate step, including whether there is intentional misclassification, the severity of the misclassification, and the film CA's track record. Possible regulatory action includes warnings and financial penalties. The companies involved will also be penalized if they are found to have had a role in the misclassification. However, so all regulatory steps will be administrative rather than criminal in nature. As Mr. Darul David said, the co-classification is indeed a collaborative effort with industry to ensure that films and videos meant for distribution and public exhibition are rated in line with the film classification guidelines. So since the co-classification pilots were launched with video distributors in 2011 and film exhibitors in 2015, IMDA has trained and certified 81 film CAs, and almost all co-classified titles are in line with IMDA's own ratings. So we therefore believe that the industry is ready for the scheme to be formally introduced. So I would like to reassure Mr. Kok that the scheme will also remain optional, so that those who prefer to do so can continue to submit films to IMDA for classification. It is an additional option. Film CAs have to classify the films with reference to the film classification guidelines, which is no different from what IMDA does today. The safeguards in place will help to minimize misclassification risks, and we do not believe we would stifle the creative space for the industry. Mr. Darul David also asked why co-classification will only apply to films up to PG-13. So I would like to reiterate that we are beginning with co-classification for ratings PG-13 and below to reduce the potential impact of any misclassification. So we will consider whether to allow co-classification beyond PG-13 in time as the industry grows more familiar with the classification guidelines. Both Mr. Louis Ng and Mr. Kok Heng Leun spoke about the prospect of consumers missing the uncut film should film CAs edit films to qualify them from lower ratings, and asked if we could require all edited films to be expressly listed. So I wish to clarify that this is not a classification issue. It is a commercial one. Decisions on whether to edit a film and what film versions to screen are purely commercial ones made by film distributors or exhibitors. Some do release different versions for different audiences. So I thank Mr. Ganesh Rajaram for raising the examples of the film Last Caution. Another film Another example is the film Attack on Titan, where two versions were screened in 2015, one rated M18 and the other edited for NC-16. In these two cases, the distributor decided to screen different versions so that the films were viewed more widely. So I think this is the right approach, as distributors and exhibitors know their customers best and can decide which version of the film is the most commercially viable. Second, members also spoke about the changes in IMDA's regulatory scope. I thank Mr. Rajaram for his views on the video game class license scheme. While it is true that online video games purchases are rising, as Mr. Rajaram noted, these often require credit card or other online payment methods that might mitigate the risk of underage consumers buying games with mature content without their parents' consent. However, in contrast with online games, anyone can walk into physical stores and buy age-restricted games today without proving their age. So going forward, the class license conditions will make clear that retailers must also play their part to protect our minors by ensuring that M18 video games are not sold to underage consumers. Mr. Louis Ng asked what the intent was in regulating the public exhibition of films that are digitally transmitted, and if this amendment would bring the streaming of films under the FA's ambit. So I'd like to reassure the members that the amendments will not affect those who view films in the privacy of their homes. The amendments are to ensure that the public exhibition of films is regulated under the FA, whether they are screened from a recording or from a digital transmission. The focus is on public exhibition. Associate Professor Daniel Koo asked if several scenarios would be considered public exhibition or otherwise. So I believe when such cases arise, IMDA will look at them holistically and consider the facts and circumstances involved. For instance, if you're watching a movie on a mobile device in an MRT station and someone peers over your shoulder to watch the same movie, that, sir, is not considered public exhibition. That's called being capo. Mr. Zaki Muhammad and Mr. Louis Ng asked about the new terminology, refuse classification, and whether the film would be viewed by IMDA before making such a decision. The short answer is that this is simply a change in terminology. Today, a film is not allowed for all ratings or NAR when it exceeds the film classification guidelines and is not suitable for distribution and public exhibition. However, it is often not clear to people if NAR is a rating or not. The new term, refuse classification, will be more accurate in describing IMDA's decision to disallow the film for distribution and public exhibition. So for you to disallow, you must know what the film is all about, right? So, sir, there is no change to IMDA's classification process. IMDA will continue to review the film and provide reasons for its rating or its decision to refuse classification. So this will be the same for film CAs. In fact, Section 15 of the bill requires IMDA to view a film before it decides to refuse classification. IMDA must also give reasons for deciding as such. Mr. Louis Ng and Mr. Kok Heng Leun also asked what the films that might be refused classification under Section 16 are, where IMDA will refuse to classify any film that, I quote, contains any material prescribed. So this refers to existing film content elements that exceeds the R21 rating in the film classification guidelines. For instance, gratuitous depictions of extreme cruelty or content that glorifies substance abuse. Going forward, sir, these elements would be prescribed in regulations, and the provision cited enables it. This will be transparent, as they will be published in the Gazette. Third, members also commented on the amendments to strengthen the classification and appeals process. Mr. Zaki Muhammad and Mr. Darrell David asked why IMDA needed film reclassification power since there is already an existing appeals process for film classification. So with the formalization of the co-classification scheme, IMDA may need to reclassify films in certain situations, such as where a film CA has misclassified a film. IMDA may also reclassify older films when there are relevant changes to the film classification guidelines so that their ratings are up to date. So Zaki Muhammad also asked if there are safeguards in place. So IMDA treats public feedback on film ratings seriously and will give due consideration to the diverse views of our society. IMDA will have to weigh such feedback against the film classification guidelines, which help to ensure consistency in standards applied to all film content. For contentious films, IMDA will also seek the views of the Film Consultative Panel, or FCP, which comprises a cross-section of Singaporeans. So IMDA is keenly aware that frequent changes in classification decisions will create uncertainty for the industry and consumers. So I'd like to reassure Mr. Zaki Muhammad and Mr. Darryl David that IMDA will therefore reclassify films only after careful consideration. Such decisions by the IMDA are also appealable to the Films Appeal Committee, or FAC. So on films with national security, let me first thank Mr. Ganesh Rajaram, Mr. Zaki Muhammad, Mr. Darryl David for their support for this amendment for the Minister to hear appeals involving these films. Mr. Zaki Muhammad and Mr. Darryl David, as well as Mr. Louis Ng and Mr. Kok Heng Leun, also asked several questions, including what would constitute a film against national security and how the new appeals process for such films would be like. So as mentioned earlier, national security is one of the government's core responsibilities. We cannot outsource or delegate our responsibility to safeguard the security of Singapore and Singaporeans. Considerations of national security include what would be detrimental to the continuing existence of the country, its ability to exercise its sovereign rights, and the safety and the security of its citizens and their way of life. In determining whether a film is against national security, IMDA will also consult the relevant security agencies. However, sir, these agencies may face constraints to share the full extent of their security concerns and sensitive information with the FAC, as its members come from non-government sectors and do not have the necessary security clearances. So it will be better for the Minister to decide on such appeals, as he will be able to consider the appellant's views together with IMDA's consideration and the detailed assessment from security agencies. So the Minister will also consult the FAC for its views before making his decision on the appeal. And we do not disagree with Mr. Kok Heng Leun that it would be useful to set out some considerations broadly, which I've done here. But sir, given the complex nature of national security matters, the prudent approach would be to avoid binding this in legislation. In refusing classification, let me assure members again, the IMDA has been and will continue to provide grounds for its decision. Should there be appeals for films with national security concern, I envisage that we will adopt an appeals process similar to existing ministerial appeals, where the appellant and IMDA would be given due opportunity to make their respective cases to the Minister via written submissions. Where possible, the Minister will also provide the appellant with the grounds of his decision. So Mr. Louis Ng, Mr. Darryl David further asked about the rationale for the provisions that deal with films that are against national security, given existing laws such as the Internal Security Act. So these existing laws serve different purposes. The FA governs the regulation of films, regardless of the content, theme, or concern. It provides the film industry and the public with a single point of reference and clarity on the regulation of films in Singapore. This is a practical approach, given that any one film can contain multiple content, themes, or concern. So the FA also allows for a calibrated approach, depending on the nature and gravity of any undesirable content. For instance, films that are refused classification for exceeding classification guidelines are not allowed for distribution and public exhibition, but private viewing is allowed. However, it will also be an offense to possess films that are prohibited under Section 35. So on the FAC's composition, Mr. Zaki Muhammad asked how we could make the FAC more representative, while Mr. Kok Heng Leun, Mr. Louis Ng, and Mr. Darryl David asked about appointments and if more could be done to appoint members from the film sectors or civil society. So the FAC already comprises individuals from diverse backgrounds, representing our various communities, the creative, legal, and education sectors, as well as academia. So we agree with Mr. Darryl David that experience is important. There is thus also a mix of newer and more experienced members so that the FAC brings in new perspectives while maintaining an understanding of past decisions. So the appointment process also considers nominations from various community groups, such as Mendaki and Sinda. So we are open to considering individuals from the creative and film sector, but they should be appointed by the Minister in their own capacity and not as industry nominees. The FAC's role is to hear appeals involving film classification, which takes reference from our community norms and values. The FAC therefore has to reflect the range of perspectives that make up our society. So Mr. Louis Ng and Mr. Kok Heng Leun asked several questions about the FAC. So I'm not able to respond on the FAC's behalf, but I understand that the FAC generally allows appellants to present in person and will also share its grounds for decision with appellants. So this is already the case. So I also understand that FAC would consider allowing appellants to present in person too before forming its views when it is consulted by the Minister on appeals regarding films with national security concerns. So Mr. Louis Ng and Associate Professor Daniel Goh also asked what would constitute a prohibited film. So films are prohibited under Section 35 of the FA. It is intended for films with the most egregious content, where even possession of the films will be contrary to public interest. Examples of such content include films that advocate violence or films that threaten racial or religious harmony, the broader fabric of society, or public confidence in our institutions. So the Minister will have to exercise his judgment on whether it is necessary to invoke this section, and I think we have been very judicious, as pointed out by my Senior Minister of State. We've only had 2 films so far that we have prohibited. So this section ensures that we have some safeguards against the most egregious content to protect larger societal interests, even as we have moved away from censorship towards classification. Fourthly, sir, I thank all honourable members who spoke about the extension of IMDA's enforcement and investigation powers. Mr. Zaki Muhammad asked how IMDA has been enforcing against FA offences given the current gaps in enforcement and investigation powers. Currently, sir, IMDA seeks the assistance of the police, for instance, to investigate offences involving unclassified films when they are discovered and seized. Mr. Zaki Muhammad and Mr. Louis Ng asked if IMDA has used without warrant powers in the past, including the use of reasonable force to obtain entry, and if extending these powers are really necessary. Mr. Kok Heng Leun also asked about the rationale for these powers. First, I will clarify that without warrant powers are not new. IMDA already has these powers for some offences, such as those involving unclassified films. IMDA has also been circumspect in invoking these powers. They are meant for serious offences and for situations where IMDA has to act quickly in order to secure evidence. IMDA enforcement officers have entered business premises to seize unclassified films intended for distribution or exhibition. However, people have generally cooperated and allowed access after IMDA enforcement officers identified themselves. So IMDA has not had to use forced entry. But these powers are still necessary, as we cannot expect compliance in every instance. IMDA has to be able to respond to a broad range of enforcement scenarios to be able to protect the public interest, but it has been and will continue to be circumspect in invoking these powers. Mr. Zaki Muhammad, Mr. Kok Heng Leun, Associate Professor Daniel Goh, Mr. Louis Ng, Mr. Ganesh Rajaram, Mr. Darryl, in fact, everybody who spoke also asked about IMDA's enforcement officers, their training, the extent and the limit of their powers, and how IMDA would ensure that they exercise their powers responsibly. So let me begin by thanking those who contributed their views during the public consultation of the bill. Their feedback, in fact, has been very useful. On enforcement, it has helped us to gain better appreciation of the concerns about without warrant powers for entry, search and seizure. So we have made several adjustments. First, we have limited the extension of powers to serious offences, such as those involving prohibited films and the unlicensed public exhibition of films. I explained, sir, the egregious nature of prohibited films earlier. For unlicensed public exhibition, the risk and the ease of flight is high, as an exhibition typically lasts 2 hours or less. But for less serious offences, a court warrant or permission from the owner will be needed for IMDA to exercise these powers. Second, sir, we have also limited the exercise of these powers to IMDA's enforcement officers. These officers currently already have to and will continue to attend and pass the home team investigation courses, where they receive both classroom and practical training alongside home team officers in areas such as powers of entry, search and seizure, collation of evidence, recording of statements, and preparation of investigation reports. There are 3 phases of training with the home team: 3 weeks of basic training, 1 week of intermediate training, and 1 week of advanced training, with annual refresher courses for all officers. The enforcement officers are also security vetted, and the majority have prior experience in law enforcement agencies. To Mr. Kok Heng Leun's question of which other individuals may assist IMDA officers in exercising the enforcement powers under the Act, this refers to auxiliary police officers and IT forensic engineers. It does not refer to other IMDA officers. Third, sir, we have specified in the bill that without warrant officers will only be used when the enforcement officer has reasonable grounds to suspect that the specific serious offences have been or are being committed, or that evidence of the commission of these offences can be found in the premises and it is necessary to secure it from being concealed, lost, or destroyed. So I'd like to reassure Mr. Zaki Muhammad, Mr. Louis Ng, Mr. Kok Heng Leun, and Associate Professor Daniel Goh that only items used in the commission of the offences would be seized. What is seized, of course, will depend on the specific offence. For instance, for unlicensed public exhibition, IMDA officers are likely to seize the storage medium where the film is kept, but not the projector or the exhibitor's mobile phone. For distribution of unclassified films, the officers will only seize the copies of films that have been displayed or intended for distribution, but not personal items, such as the distributor's mobile phone. During the investigation of seized items, only materials that are relevant to the offence will be flagged as evidence, while the rest will be protected and will not be disclosed. So this is similar to conducting a physical search, where enforcement officers will have to go through the storage space before extracting what is relevant. IMDA's interest would only be on materials that serve as evidence. We have also provided an avenue for owners to challenge seizures of the items in court. Generally, sir, IMDA will return seized items after investigations conclude. So these limits and safeguards will be set out clearly in the Amended Films Act, which will be publicly available. Mr. Zaki Muhammad and Mr. Kok Heng Leun also asked whether we could continue with this current arrangement of relying on the police in areas where IMDA does not possess the necessary powers. So IMDA, as our info communications media authority, is best placed to enforce and administer the FA. It has the necessary domain expertise, and its officers also understand and appreciate the work of the media and film industry. Extending IMDA's powers to close the enforcement and investigative gaps will enable IMDA to administer the act effectively. It will also allow the police to focus on other threats to security and law and order. So I believe this approach is in the best interest of both the film industry and Singaporeans. Mr. Zaki Muhammad, Mr. Ganesh Rajaram, and Mr. Louis Ng also asked how IMDA will ensure that these powers are exercised responsibly. So I would like to assure the members and Singaporeans that IMDA has put in place robust internal processes. First, all enforcement activities have to be authorized by suitably senior IMDA officers holding the office of a director or its equivalent. Verification is done to assess and ascertain the veracity of information received on potential offences committed and/or the identity of the potential offender. Enforcement action will only be authorized if a prima facie case is established. The senior IMDA and enforcement officer will also be apprised of the operational plan and the rules of engagement before any action is taken. So I also like to reassure Mr. Rajaram that any person who deliberately gives false information to mislead IMDA to initiate enforcement actions will be committing an offence. Second, enforcement officers are undertaken by team of enforcement actions are undertaken by a team of enforcement officers led by an experienced team leader. New or less experienced officers do not carry out enforcement actions on their own. Team leaders leading enforcement activities have at least 5 years of enforcement experience. Third, to safeguard against abuse, each enforcement officer is issued with an authorization card that is distinct from the general IMDA staff passes. It is spelled out in the bill that enforcement officers must identify themselves with us, failing which entry can be refused. Fourth, an established whistleblowing policy is also in place, where members of the public can lodge complaints of abuse. Investigations will be conducted by IMDA's internal audit unit, which is independent of IMDA's regulatory and enforcement division. So IMDA takes the abuse of enforcement powers very seriously. Depending on the severity of the accusation and the evidence given, IMDA may deploy the accused officer to an administrative post during the investigation. If the allegations are true, internal disciplinary procedures will apply, including the prospect of dismissal. Finally, sir, I will address questions raised on issues beyond the scope of the bill. Mr. Kok Heng Leun asks why the making and the reproduction of party political films or PPFs would remain an offence under the FA or more broadly, why there is no amendment to the PPF provisions. Associate Professor Darung also asked about norms regarding politics in films. Sir, the PPF provisions were introduced in 1998 to keep our political discourse sober and rational. And sir, by a quirk of history, I was on the other side of the chamber debating the same bill in 1998, 27th of February, sir. Sir, the amendments, they were then amended, the Film Act was then amended in 2009 to examine and allow political films that are factual and objective and do not dramatize or present a distorted picture. So Professor Ng is not since 1998, but 2009 there was another amendment. So we have reviewed the provisions and are of the view that they remain relevant. Mr. Louis Ng shared, films can be emotive and powerful and shape one's worldview for a long time. So it is one thing for gorillas in the mist to inspire someone to devote his life to animal welfare, but another thing for distorted or sensationalized films to undermine a democracy and alter the course of a country forever. Film, sir, is not an ideal medium for political debate. Serious political issues could be sensationalized or distorted to evoke emotional rather than rational reactions. Films do not allow for effective rebuttals, and there's a risk that political debates on serious matters could be reduced to a contest where parties and candidates promote themselves, attack others, or mislead voters through sleek commercials and slanted presentations. We should thus not compare PPFs to other films. They are a different category of films given the impact they could have on the integrity of our elections as well as the broader political discourse. It is therefore prudent to retain the provision so that we can continue to ensure that political debates in Singapore remain grounded in fact for the greater and longer-term good of Singapore and Singaporeans. Nevertheless, sir, I would like to reassure Mr. Kok Heng Leun that IMD will continue to be judicious in administering these positions. Should cases like the one Mr. Kok Heng Leun described arise, IMD will look at them holistically and consider the facts and circumstances, including the larger intent behind the PPF provisions to keep our political debates and broader political discourse sober and rational. So in conclusion, let me reiterate that this set of amendments will help to update the Films Act and bring it in line with technological developments and shifts in our films and media environment. Many of the changes are for the better, but there are changes that also pose very real risks for us. We are still a city-state with different races and religious groups living closely together on a small, dense island. We believe that the amendments are a right step towards finding a course in an increasingly connected and complex media landscape. Sir, back to move.
Mr. Kok Heng Leun. Thank you, Deputy Speaker. I'm actually responding to just now my honourable member's colleague, Mr. Darrell David, talking about artistic freedom and artists at work. I just want to clarify that most artists do not make work in order to express artistic freedom. I think artists make work because they pick up on things that they think is of great concern to them. And that's why when they bring out something in concern, sometimes it may not, fall within the comfort of certain particular group of the society. And that's where the dialogue happens. And secondly, which is about the creativity and within the container, I think a lot of the artistic work, while it starts from within the container, I think the intention is then to withdraw the container or even get out of the container. How can we always say, know the frame where you are in so that we can break away from the frame to create new possibilities. The last thing that I would like to address to the Minister was that I really hope that the Minister, whenever there is an appeal, especially for those unclassified, to look at those films that may be unclassifiable, that the Minister allow for a personal appeal to see the filmmaker face to face. I think that will make the appeal much more, the process much more genuine, and the conversations and the dialogue to be much more in-depth. Thank you.
I would take it that your last point, you're seeking Minister's clarification.
So on the first point about creativity in a container, I just want to clarify one point. I think in his speech, Mr. Kok gave the impression that with co-classification, it will stifle creativity. Actually, that's not the whole intent. The whole intent is really to allow some distributors to co-classify, but it means that you can also make a film for any of the classification rating that is available out there. The example that I gave, the example that Mr. Rajaram gave, is a good examples to demonstrate that filmmakers can actually make a film from R21 all the way downwards to G if they want to do so. It's their choice, basically. So I don't think there is this co-classification scheme that we have introduced, or we will introduce after the Act is amended, will stifle the creativity of filmmakers. If anything, from the consumer's point of from the distributor's point of view, it's a lot more efficient for them to bring the film to the market. But I agree with him that creativity is important because we want to continue to build our film industry to be dynamic, and so that at the end of the day, we can be a place where people want to come and be here. On his second point, as mentioned in my reply, the process that we've adopted will follow all other ministerial appeal process. And in most of the process, basically, if not all, we basically deal with the agencies and the agencies who are involved to give us the submission, basically. So I think we'll retain that for the moment, and we allow it to work out and see how it works, and then we will evolve from there and learn from the experience.